Thank you very much, Phil. Good morning, everybody. My approach to this topic, I should say right at the outset, is this for me, I guess given the nature of the work, is a very practical, more than legalistic concept, and I've framed my remarks that way for the purpose of of this presentation. Ideally, this is a topic, and I was discussing this with Phil and Owen earlier, that I think is better suited for dialogue rather than lecture. But given the format and the constraints upon us in relation to folks that are watching via the web, we're going to do our best to exchange some ideas, hopefully. I'm not going to leave you with any cliffhangers here this morning. And if you take anything away from what I'm going to talk to you about today, it's this, in relation to sentencing, and in particular in relation to creative sentencing. Creative sentencing, to be viable, to be effective, is all about logistics. And I'm very envious, I have to say, having seen the papers of some of the other participants. It seems to me in some other Canadian jurisdictions there's an administrative infrastructure that accompanies creative sentencing, and that's something we don't necessarily have at least formalized in Nova Scotia. And my own personal experience with creative sentencing is that the successes we've had, there has been firm supervision, monitoring, and feedback in relation to any creative sentence that has worked and worked well. I have to tell you something. I guess this is maybe something of a confession. We're here at the Schulich School of Law, where I spent 3 years some time ago, and I was here yesterday with my boss for the sessions. And at one of the breaks in the morning, we got up and had to go to the washroom. And for those of you that are present here today, you'd know that we're in a seminar room on the first floor, and the library is upstairs one flight. And we went up to the library looking for the washroom, and my boss was very surprised with me, having spent 3 years here, that I didn't know where the washroom in the library was. Now, I guess I'll look over at you, Phil. I choose to believe that washroom's been moved since I've been here last. Anyhow, I guess to turn back to what we're meant to be discussing, I want you to think about a little bit the perspective of counsel when it comes to negotiating sentences. And again, I don't think this is necessarily going to carry over for folks not in the room today, but I'll ask the question and see if I can get a response that I can communicate to the web participants. How many folks in this room would be involved or would have been involved in the development or the evolution of a creative sentence in court? And by that I mean, say, from conceptualization through to discussion, and or perhaps through to implementation. I just get a sense of how many folks here.
Peter, you're talking about, you said court, are you talking about court ordered or?
Yes, court ordered.
Yeah.
I don't know if folks could hear the question I had, that was posed. I was asked if I was talking about court ordered creative sentence, and that is indeed my focus. So we've got a couple, and I guess I'm going to pose a question, and I'm not looking for an answer right now. I wonder, and I think my colleague Paul would certainly be included in the mix. I wonder if folks other than myself would agree that logistics are crucial to the success of such things. Certainly the thrust and tenor of many of the presentations thus far, people are advocates for creative sentence, and I include myself amongst those folks. But I guess what we've learned, at least here in Nova Scotia, is that sometimes creative sentences are not necessarily the way to go. And I'm going to make my best efforts to give you a feel for how a sentence evolves, and what criteria may be at play to make an individual case viable for a creative sentence resolution. That's certainly my objective here this morning. One of the things, I mentioned this in my paper, and I'm just going to touch on it briefly. In Nova Scotia, like many other Canadian jurisdictions, all provincial offenses are governed by our Summary Proceedings Act, which incorporates by reference the substantive and procedural sections of the criminal code in terms of how provincial statutes are prosecuted. And I know there are some other jurisdictions that are set up similarly. There's a Provincial Offences Act and other jurisdictions and similar legislation. I've made a point in the paper, and I'm going to repeat it just for emphasis here today. That brings into play, before looking at what I think of as the contextual sentencing principles for any type of public welfare legislation, superimposed on that are the criminal code sentencing provisions, and in particular, Section 718, 718.1, and 718.2. These are all enumerated in my paper. I'm not going to bother repeating them. You can look at them yourselves. But those principles, and I have judges in this province, I suspect my colleague Paul Adams might have a similar experience. We're reminded regularly that those principles apply to this process. And the significance of that for me is that that affects particular sentencing options that a particular case might present. So it's important to keep those criminal code sentencing principles in mind. They're the first principles, at least in terms of this exercise, as far as I'm concerned. I'm going to make a segue to the theory of creative sentence at this point. And this is a discrete topic, I suppose, where I have more questions than answers, and maybe some of you do as well. The touchstone question I have here, I guess, is how actually creative have we been when dealing with creative sentences? Some of the other speakers who have addressed this topic have talked about the historical evolution of creative sentences in this country and in different jurisdictions, and actually you have also a comparative perspective from Australia. Creative sentencing is not necessarily a brand new topic for any of us in 2014. There are constraints, I think, at least from my perspective, on the implementation of creative sentence. I would be very interested in talking to other individuals from other jurisdictions about their experience with anything novel that's being done. It seems to me, particularly in the environmental sphere, the creative sentence options aren't that creative. There's a tendency to use ones that have worked in the past. Certainly the ones that we see here in this part of the country and watching what's happening at a national scale, for example, publication, donations, things of that nature. I wonder, question I have is if people are considering the viability of any more robust sentence options beyond that. Are there any that are particularly suited for environmental law prosecutions? What is occurring and what guidance can we take in environmental law prosecutions from developments that are occurring in the creative sentence front in other regulatory fields? Something I'd ask you to think about. Can this inform the evolution of creative environmental law sentences? If you look, and I made a point to look and kind of contrast the Australian legislation that we've been hearing a little bit about. And this, our colleague, Ms. Masher, provided this. I don't want to oversimplify, but the creative sentence legislation in New South Wales, I'd go so far as to say it's not qualitatively different significantly from many Canadian jurisdictions and certainly under the new federal regime. And in Nova Scotia, for example, under Section 166 of our Act, there's the potential for lots of different variants of creative sentence. And again, I wonder how often and how much practitioners are thinking of things beyond what has now been historically done with creative sentence in different jurisdictions. We have a basket clause in our legislation in this province. It's 166 sub I, and I'll read it. This empowers a sentencing judge to make an order requiring the offender to comply with any other conditions the court considers appropriate in the circumstances for securing the good conduct of the offender and for preventing the offender from repeating the offense or committing other offenses. That's some pretty broad jurisdiction. And I guess I'd go so far as to say the legislators, in my view, are encouraging practitioners to turn their minds to creative solutions. So that is something I'd ask folks that are in the business, in the prosecution business from both sides, to turn their mind to. And just to touch on the subject area comparison and what we can draw from that from environmental law prosecutions, I don't claim this as any unique or insightful observations, but one of the other regulatory prosecution subject areas, I think, where we can take some guidance from on creative sentencing is in the occupational health and safety area. And let's start again with the first principles. Everybody in this room, I think, is well familiar with the sentencing principles set out in United Keno Hill Mines. I'm not going to regurgitate all the particular factors. They're well known to you all. But in the occupational health and safety field, the benchmark case, I think even now, setting out sentencing factors is still Cottonfeld's. And if you were to take the sentencing factors that emerge from Cottonfeld's and write them down on a piece of paper and put it here where my right hand is, if that's visible on the web, and then do the same thing for Keno Hill Mines, I don't think you'd see anything significantly different. It's the same criteria essentially, and frankly, the criteria in each of those contexts isn't markedly different from sentencing criteria in any other field of regulatory prosecution. And I'm not trying to make too sweeping a generalization, but and perhaps Paul or others may have some comment on that, but you're essentially looking to achieve the same objectives in every instance, essentially. So for me, that begs the question, what can we learn from creative sentencing and other regulatory enforcement sectors? What can we learn? What has worked? What hasn't worked? And I think our federal colleagues here, and Paul is one, their experience can assist all of us as well with this. One of the things, and I noted, I believe in Ms. Chesson's pieces, that she noted as the key to the success of creative sentence outcome. I'm of the view that this has to be brought to the court by way of a joint sentence recommendation. And I'll tell you why I say that in a second, but first I'm going to pose another question to those that have been involved with this exercise before occasionally. I guess what I'd be curious to find out is how often, if at all, you seriously entertained making to a judge, and this would be a question I'd ask Crown and defense, how often you'd seriously entertain recommending creative sentences to a judge in a non-joint sentence recommendation scenario.
Yeah, I've done it, but I've got to say this, that my experience when I was on the federal Crown prosecutor side was most of the dispositions, if they went to a guilty plea, were by way of a joint sentence submission, but I've done the other side of it where I've already contested sentencing.
Okay. I'm just going to do my best to, and I hope I'm not trying to recapitulate what you're saying, but for the benefit of those who aren't in the room, I'm taking from that it's happened, it's occurred, but in most instances they follow a guilty plea where you've essentially negotiated a framework for a joint sentence that you're going to ask a judge to impose. Is that a fair characterization? Okay. Well, I'll tell you my experience, because maybe when I was a little more naive, I made an attempt on a couple of instances to go off on my own and recommend creative sentences, and they haven't worked particularly well. And I guess, as this subject evolves, that's necessarily going to be part of the process. And the reason why, in my humble opinion, it hasn't worked is creative sentences are only going to work when you have full buy-in to the process of either the individual defendants, or if you're dealing with corporate defendants, the principles of corporate defendants, not folks lower down on the chain of command. It has to be the principles. And if you don't have buy-in from those individuals, a creative sentence is not going to work. And I'll go further than that. A creative sentence is not only not going to work, it's going to be counterproductive. it's going to defeat the entire purpose of the exercise. So let me tell you how that manifests itself for somebody like me. One of the things that's interesting, even at this stage of the evolution of creative sentences, and I don't think any longer we're in the genesis stage of creative sentences. These things have been on the books for a while now. I don't know if we would call it adolescence or what stage in the evolution, but you know, we're a little bit out of the gate at this stage of the game. My experience is I need to know that if we're going to seriously entertain a creative sentence regime, the defendant and the person of the individual defendant or the principles of a corporate defendant is fully invested in making this work and making it work properly. Because otherwise you're wasting my time. Because in order to make a creative sentence regime work, there are a lot of people involved, folks. It is not just the defendant and the prosecution service. The court has a role. The court has a role, in Nova Scotia at least, in a supervisory capacity, and as our creative sentence orders have evolved over time to this point, what we do now is we ask judges to retain an implementational jurisdiction or a supervisory jurisdiction over a sentence order. I don't know if that's common in other jurisdictions. I haven't had any difficulty whatsoever with getting judges to agree to exercise this jurisdiction. My experience has been, frankly, the judges have embraced creative sentencing. But judges, at the same time, they want to know, how is this going to actually work in the real world? Because a judge, again, in my experience, does not want to make a sentence order that they know is not practically enforceable. So, for example, let me give you a concrete example of what I'm talking about. If you order a defendant in an environmental context to publish an account of what happened in some media outlet or journal or something of this nature, what I'm asking folks assembled here now and that are listening that are not involved in the actual development of the sentence, how do you think that occurs? How do you think it monitors? I can remember one of the first occasions where we did a publication that I had been personally involved in. The copy, and I'm grateful we caught this before anything ran, looked more like promotional advertisement for the defendant company than something that was coming out of the court order. There was no mention of the facts of the offense, really a significant mention, or the fact that the defendant company was being ordered to publish this. Now, we were able to catch that before any significant damage was done. But if you think about that a little bit more, you may consider for a second, what happens if you can't agree on the content of the publication? And I'd be curious to find out what happens in other jurisdictions. Our sentence orders now allow for an adjudication of any dispute by the sentencing judge throughout the course of the order, if this happens. And judges in Nova Scotia haven't had any philosophical difficulty with doing that. And again, my own experience is they want to ensure that the spirit of the sentence order they issue is implemented. Owen?
Yeah, Peter, is this actually a practical problem, or does the threat of adjudication essentially resolve most of the problems in terms of whether or not the order's been complied with?
So I'll just repeat Owen's question. He asked if this is really a practical problem or whether the threat of an adjudication, bringing the matter back before a sentencing judge is effectively the deterrent to avoid a problem. And I guess a typically lawyerly answer, I'm going to say to you both, because we've had to exercise or ask a judge to exercise that jurisdiction in a couple of instances, and just to ensure. The form of order that I've been using is that, and I'm going to come to my favorite creative sentencing option, and that's presentations in a second, but the same kind of wording attaches to a sentence order that relates to publication. It would read something like this. The defendant is hereby ordered to make a publication of the facts of this offense, facts and circumstances of this offense, and in many instances required due diligence and violation of particular provisions in the act, or some form of that wording. And the form and content of the publication is to be mutually agreed as between the investigating department and the defendant. And in the event of any dispute, this court retains jurisdiction to adjudicate and resolve the issue, or something along those lines. That's how we in Nova Scotia deal with that, and that's why I noticed in Ms. Chesson's paper, I was very jealous, I have to say, that they seem to have in Alberta some sort of creative sentence administrative infrastructure. And I don't know if that's the case or if it's that formalized, but I suspect they're further ahead of the curve than we are in Nova Scotia. But that's how we attempt to snooker those issues. And I can tell you there are lots of practical problems in relation to publications. What media are you going to utilize? What is the best? We have dealt with very interesting for someone like me, and I don't purport to be a communications expert by any means, but we've had cases, occupational health and safety fatality cases. And again, this is where I think the experience in other prosecution sectors can spill over very helpfully to what we're doing in the environmental law field. We have in Nova Scotia, we used to have a couple. I think there's really only now one provincial-wide newspaper in circulation, and that was usually for, I guess, someone like me, what I figured to be the best communications mode for this type of publication. And we, in one particular case, consulted with some folks in Communications Nova Scotia, which is an arm of the provincial government, and we were told quite unequivocally, you know, you may want to be looking at using local newspapers. These are the ones that people look at and read carefully. And you're going to get the most bang for your buck from that type of communication mode than others. Electronic media now, other types of and forms of communications. These are things, you know, that I, as a prosecutor, an expertise in this subject matter, that's not something I purport to have. I need people to tell me. So when I said earlier, or posed the question, if any of you have been involved in conceptualization through to discussion, through to implementation of creative sentences, I hope people are getting a feel that there's a lot of inputs along the way, particularly if you're concerned about having an effective, responsive, creative sentence order at the end of the day. So I said to you earlier, and I'm just, I don't want to run Paul out of time here. My favorite creative sentence tool, option, is presentations. And when I started doing this work about 8 years ago, I had been a proponent of creative sentence for a while, but the work I do for our small province, I'm our Provincial Prosecution Services dedicated regulatory prosecutor, and I do work in lots of sectors. But certainly occupational health and safety, there was a volume of prosecutions that exceeded and continues to exceed those in any other sector. And creative sentencing is something we're utilizing very heavily in that area. So imagine just for a second you're dealing with a corporate defendant and there's a fatality at a work site. And the defendant is responsible, and although there was no due diligence in relation to this particular incident, otherwise is no negative enforcement history and is really a proponent of safety in the workplace. Well, as you probably know, there, in this province and certainly others, I'm sure, there are a ton of industry-specific industry associations. There are some broader ones that cover a whole range of industries, like the Construction Safety Association. And what we have been doing is we have been getting the principles, and I personally feel it has to come at that level. We've had some corporate defendants that weren't enamored with the idea of having the principals of the company conducting these presentations, and frankly, I wasn't prepared to agree to anything other than that. But I'll say to you plainly, folks, having been an advocate for these things for a few years, one of the things I figured I should probably do is go in and watch one of these things. I don't know, can I ask if anyone here has had occasion to do that? I don't know, Bill, if you in your former capacity ever has had occasion to do it. Anybody? I would urge anyone that's interested in this topic at either a practical or a theoretical level, if you get an opportunity, go sit in through one of these things. And you watch how the people in the room react to this. In many instances, you'd be dealing with a defendant company who was standing up in a room, maybe at an annual general meeting, of its peers and competitors. And they are standing up in front of everybody and they're taking ownership of an incident that happened, a tragic incident, and they essentially say, don't let this happen to you. Here's what we did. Here's what we should have done. Here's the regulatory regime. Here's what could have constituted due diligence. And again, don't be in this situation. Incredibly powerful. Incredibly powerful. There's one particular case that stands out in my mind where the CAO of a municipality in this province that was involved in a fatality stood up in one of these rooms, and she inherited the response to this incident. She wasn't on the job at the time, and she had implemented a zero tolerance workplace safety policy. And she stood up at a construction safety association that was, the audience was predominantly middle-aged men, I don't mind saying, and she had moved the entire audience within 15 minutes almost to tears. It was just one of the most powerful things I've ever seen. And the way I processed that and continue to is wow. Wow. Would that have been more effective than, a one-page advertisement in a provincial newspaper? Would that have been more effective than an account of the court issuance of a fine. I've talked to people since that remember that presentation, and these are not folks that are involved in my end of the business. These are people that I know from the community that are involved in the business end of things, and they have never forgotten that. And I have never forgotten that either. So the reason I'm telling you that story is I think that is a great opportunity, particularly with larger corporate entities in this sector, environmental law prosecutions. But, again, you have to have, there's some capacity issues. In this province, some of the environmental law prosecutions that I deal with, we're not dealing with big multinational companies. I don't know if that's the case for many of you. I suspect many of you that are involved in the provincial end of environmental law prosecutions are perhaps in this situation. There's some capacity issues you really need to turn your mind to. We've had literacy issues with principals of companies, which really militated against the use of presentations. And it wasn't anybody's fault. And in one instance, we had folks from the community college system that stepped up of their own volition to assist this individual and help him be more comfortable speaking and with his literacy that would enable him to present an effective presentation. So the creative sentencing options that I like are more human resource centric than money centric. That's not to say these things are mutually exclusive. I view the ideal creative sentence as a package, as a kind of a global entity where you would have a fine component and then you would have other creative sentence tools, a donation perhaps, presentations or some other personal investment from individuals that are involved, and something that can actually engage victims, because victims can be part of this process. And if you want to, there are a few instances in my professional experiences where victims are ever going to be satisfied or walk away happy from the court end of the work that I do. Very few. But this is one area where there's the potential to have them engaged and give them some satisfaction with the process. So I think that's about as long as I wanted to spend. I'm happy to take any questions if anybody has, or even comments. This is a topic, at least as far as I'm concerned, where dialogue and the benefit of other people's experience with the things I've been talking about may accrue to everyone's benefit.
Great. Thanks very much, Peter. And I actually will continue, if there are any written questions, we have some, we'll do those, but we'll also take questions from the floor, as you suggest, and I'll do the translation for the microphone, and we'll
Sure.
Carry through the questions that way. So we'll see if there are any more to collect at the moment. Okay, so I have a couple, and then we'll turn it open to the floor. The first, one of the elements of realism which you've introduced is with respect to the administrative and technical support available to prosecutors, at least in this province, and I suspect in others. Does the lack of that support also hamper, in addition to the monitoring of orders afterwards, does it hamper the development of an appropriate plan for a creative sentence, for example, in a technical area like remediation, environmental remediation or similar?
Short answer to that is yes.
Okay.
I'm not going to give you a short answer, but it certainly is the case. So I guess most of us here would know historically fines were the predominant way regulatory offenses were resolved by way of sentence. So what that means is that enforcement agencies really never devoted any time or resources to anything post-trial or post the laying of a charge in a guilty plea scenario. The investigators that I deal with, their historical perspective on prosecutions is, you know, you lay the charge, you testify. I don't know, Paul, maybe you deal with less grizzled and cynical investigators than I do. They lay the charge and they're done. They can hardly wait. This is your baby now. Now, thankfully, not everybody approaches their work that way, but there isn't any formality associated on the front end with developing a plan. I seldom see a file that comes into my office, you know, with something accompanying the Crown brief that says, you know what, here's one that may be tailor-made for this form of a creative sentence. That dialogue probably won't happen unless I initiate it, and I'm not saying that to make this unique to myself, but that would be the same for any of my colleagues, and maybe in the federal sphere as well. I don't know. Paul can speak to that.
This next one, I'll elaborate a bit on what I've been given, but it seemed clear one of the issues you raised and pointed to, which came up a bit yesterday, is that some of the more truly creative or elaborate forms of creative sentencing have involved large corporate entities, which would seem to indicate that they may be the source of some of the options that are being developed rather than in the prosecution or somewhere else at times, or at least they have the capacity to do it. One of the responses to that, which you've mentioned in your paper and others have as well, is using NGOs as a conduit for funding from a creative sentence process. Do you see difficulties, or have you had difficulties with that process? And in particular, how do you decide who should be the recipient of funds? For example, is there some transparent process whereby an NGO with an interest and a link to the environmental harm can make a case for their access to such funds for a specific purpose?
So I guess there's a few elements to that question. I'll just try and break it down. We've had to scrutinize potential donee recipients. I don't purport to know, for example, whether a river preservation society in a fairly rural area of our province is a bona fide entity registered at joint stock companies with directors and that would make annual filings, things of that nature. I don't know that. We have to check those things out. I can tell you I would look to the investigators to check that out. We're positioned maybe to make some very cursory inquiries, but I think if this process is to have any credibility, the last thing you would want to do as a prosecutor is wind up engaging into the process an entity that really was not bona fide. So those are things that really need to be looked at. In Nova Scotia, there is no formal process. Mm-hmm. I have to tell you, at least our prosecution service doesn't have one. We work in conjunction with the department to identify something. Now, I'm going to turn now to the first part of your question. I agree with that observation, Phil, that when we who are interested in what sort of creative sentence orders are happening on a national scale, my own experience, all of the defendants seem to be multinational or large companies. And how well they fit for a case I'm dealing with in Nova Scotia is something I always have to gauge. But I will say this to you. If there's going to be a discussion of creative sentencing with counsel for a defendant, that discussion is almost exclusively initiated by the Crown. Now, maybe that's not the case in other jurisdictions where creative sentence has been more embraced by the defense bar. And if that is occurring, I would find that a very positive and interesting situation. But we usually initiate it, and then the exercise turns, and I've laid this out in my paper in terms of mechanics, how it's going to work, what logistics are involved, what sort of supervisory regime is going to be imposed, how is form and content of certain things going to be resolved. But, and again, maybe Nova Scotia, we're in the stage of our evolution, we're a little bit behind other provinces or other countries, even for that matter. We usually trigger that process and those discussions.
Anything from the floor? Yes.
Thanks, Bill. With respect to the term of an order or a presentation, what input do you as Crown Counsel have on the content of that presentation? And for that matter, is there a role for the court? Are you doing what you do in other aspects where you're just ensuring that there's some kind of approval by the investigating agency that this works, this is the message that we want to see?
Right.
So just summarize that.
If you would,
question
please.
relates to the extent to which the Crown would have input into the content of the presentation under an order, and also the extent to which that might be molded by the investigators and/or the court, if I've got it right.
So here's how I personally tackle that. I would, and we usually draft the form of order that the judge is going to issue. Not always, but I would say 90% of the time. And the form of that order would read something very similar to what I was talking about with respect to the publication earlier. The defendant will be ordered to conduct 8 presentations through Fishing Safety Association of Nova Scotia, for example. And there'd be a time frame stipulated in the order, over the course of a year perhaps, or 18 months. And the form and the content of that presentation, as well as the attendees, will be mutually agreed as between the department and the defendant. And what we've been doing, Provincial Department of Environment, as well as Occupational Health and Safety Division, the Department of Labor, they have templates that have been used in other cases that can be shared to assist the defendant in developing something in terms of a PowerPoint presentation. And that's meant to be shared before it's effectively signed off. So that's the level of control. And if it can't be agreed, the form of order allows us to bring it back to the court for resolution before the presentations even commence. So that's the supervisory checkoff, if you will, that we've developed here, and we haven't had any difficulty implementing that. But that's how we do it. The one thing, I will say this, lest you think I'm being Pollyanna-ish about any of this stuff. I hear it. I hear it from the investigators. They say, look, we're not going to develop this presentation for the defendant.
Yeah.
They resent that, and I don't blame them for being resentful. And I make a point of dealing with, when dealing with counsel, said, look, you guys have agreed to this. We've agreed that you have somebody within your company at an executive level that can do this. Surely they can create a PowerPoint. And if you can't, you tell me now, and we're not going to go this route. But we're not going to have the department investigators create your presentation. If it was to go that route, I can tell you I'd be working at Walmart with a smock pretty quick.
Thank you. Anybody else on the floor? I have one last question on the written form, and we're about at the right time, I think, to move on. So this may just be something that's a totally hopeless prospect, I think, but is there any prospect in the future of Nova Scotia at least developing separate and appropriate sentencing guidelines for the summary proceedings, and not just sort of bringing over most of the criminal code side, or at least for some types of summary proceedings under that act?
I'd have to say I'd probably support that initiative. I won't mislead anybody here. I wouldn't see that, frankly, as being a particularly pressing priority for.
We'll take that as not on
Yeah,
cabinet's
yeah.
order paper anytime
Well,
soon.
yeah, there's a number of things, and we were talking a little bit about it earlier. I think a regulatory offense court in this province where you develop some expertise amongst all the participants, including the judges, and you heard Judge Stewart's comments about some of the restorative justice initiatives that maybe could be funneled through a forum like that. I think that would be a wonderful thing. The reality in Nova Scotia, anyone that's practiced here, are these regulatory prosecutions, which are complex and take up a lot of time on an otherwise exceptionally busy criminal court docket and provincial court. And that's the reality we face. So, and I'd certainly support the initiative.
And I think that's
by all means.
Highly realistic reminder for us to end the session on. Thank you very much, and we'll.
Thank you, Phil.
And we'll go straight on to our federal perspective, moving from the provincial to, we have Paul Adams, who's a senior counsel with the Public Prosecution Service of Canada here in Halifax, and he's going to address the same issue, but from the federal experience and perspective.
Thanks. First of all, I think congratulations are in order for being up and about at 9 a.m. on a Saturday morning. Commendable. I have to say before I start, I'm feeling a bit stressed this morning, not because of speaking to you, I'm happy to do that, but I mentioned earlier my daughter's basketball team is scheduled to play in the city championship game at 11 o'clock this morning, and I've been looking at the clock. You know, I've heard, and everyone's heard about the pressure that athletes in the Olympics face in terms of performing. You know, this opportunity comes up once every 4 years. When I hear that, I wonder whether any of these people have spent any time with a 13-year-old girl on the day before the big game. Certainly sharpens your appreciation of pressure. In terms of what I want to say here today, I'm going to try and be concise, but I think any time you talk about this subject, you have to begin with, you know, what we're actually doing. And that may sound simplistic, but it's important and it informs everything, I think, right from the decision as to whether or not a prosecution proceeds through to what an appropriate sentence may be. And as I mentioned in the little paper that I've circulated, when you're sentencing for a regulatory offense, you're really dealing with a distinct concept of fault, in the sense of distinct from what you might be dealing with in the context of criminal code prosecutions. Your primary focus is the protection and advancement of a particular societal interest or goal or value, as opposed to you know, the punishment of an individual offender. And as the Supreme Court has said, on a couple of different occasions. What you're doing in the regulatory context is really preventing future harm or the risk of future harm by enforcing minimum standards of conduct and care. So, and I think that idea really does inform, as I say, what's appropriate in terms of a sentence. The courts have identified environmental protection as a societal value of superordinate importance. I don't know about you, but the word superordinate doesn't get used a lot, so that conveys to me that that you're dealing with something that is a core value that needs to be addressed very seriously. The sentencing process, obviously, the prosecution process generally, has an expressive function. It does identify, number one, what the important public interests and societal goals are, and also identifies and expresses how important they are. And it is the result, I think, generally speaking, of a prosecution, the sentence, by which the public understands, evaluates the success, the validity of the process, and understands the importance of the values and the goals that are being addressed in the context of the process. So when you're combining this very important fundamental value, environmental protection, with this need in the regulatory context to reinforce and express the importance of that goal, it's not a surprise that deterrence, general deterrence, has become the primary sentencing principle in the regulatory context. And historically, and I think this continues, the approach is, in terms of evaluating the appropriateness, the sufficiency of a sentence, the approach is kind of a cost-benefit analysis. As I mentioned, and it can be expressed a few different ways, but as I mentioned in my paper, the idea is to make it cheaper to comply than to offend. And I think that's still, at least in the way I approach sentence negotiation in the regulatory context, I think that's still an applicable principle. That has historically resulted in a primary reliance on fines, pure and simple, as a means by which to address that. But I think, and I think it's been recognized, and I think in various ways it's been a theme throughout the presentations over the last day or so at this conference, is that that's fine to concentrate on the fine as a primary mechanism, but in doing so, you may very well be missing an opportunity to properly address and most effectively address the thing that you're trying to do, which is to advance and express the importance of a particular public or societal value. And that's where creative sentencing comes in. And I'll say just this as an aside, sometimes I think calling it creative sentencing is a bit self-congratulatory. I'm not sure how much creativity is involved. At least from my perspective, what I find is that, depending on the particular circumstances, the structure of what we call a creative sentence reveals itself. Whether it's because there's options directly related to the type of offense and what would be most appropriate to address the nature of a particular offense, whether it's suggestions or opportunities coming from the investigative agency as to what might effectively address the problem and minimize the risk of recurrence in the future. These things reveal themselves often without much effort. And I agree with Peter, it's at that point, I think, that the real work begins in terms of trying to structure something and research and make sure of the credibility of the proposed recipient or the viability of a proposed project or the content, as Peter says, of a particular presentation is there. And so it's a more of a, I'm going to say more of a practical challenge than a creative one in a lot of cases. But as I say, I think from my perspective, and I think this is the way the law has developed and the way that sentences generally have developed in this sphere, is, you know, there's a recognition that being fine-centric doesn't necessarily produce the most effective sentence, both from a deterrence point of view and from the point of view of advancing whatever public purpose or value that's engaged. A special approach is required. Now, this recognition has resulted in various commentators suggesting, you know, what the focus of a regulatory sentence in the process should be. Should deterrence take a secondary role to other values like remediation and rehabilitation? And there are other views in terms of what should drive the sentencing process and what should really be at the forefront in terms of fashioning an appropriate sentence. And I'm not going to get into the pros or cons of any of those, except to say that they all recognize that there's an opportunity to do a lot more with the sentencing process than simply hammer someone, punish an individual offender by way of a monetary penalty, end of story. There's more to be done. It is an opportunity. And I think this is something that came out of Peter's point of view as well. There's a recognition, and he says maybe we're not taking full advantage of those opportunities, even with the types of creative sentences that have been used in recent times. And I think that's probably right. I think there are other things, more advanced things that we can do, more creative. Maybe there is more room for creativity than I suggested earlier in this context. But there's no doubt that there's an opportunity to do more than simply address deterrence in this context. And I think there's a responsibility on everyone involved, and I include the prosecution, the defense, and the judiciary. There's a responsibility on everyone involved to fully explore and take advantage of that opportunity. You know, I noticed in one of the articles that I mentioned in my paper, it's an article by a Mr. Campbell. He addresses very briefly, but I think significantly, that counsel do have an important role to play when it comes to both fashioning creative sentence and also explaining to a court why it is that a particular sentence is appropriate, is responsive to the situation, and does properly address the applicable principles. And I've certainly done this myself in some of the cases. It may be to the extent that there is any reticence or reluctance on the part of a court to impose a creative sentence, to be prepared to address that and explain to a court, whether it be by way of submission, documentation, or other evidence, why it is an appropriate and credible and accountable sentence structure. Now, I can say, another thing I noticed was in that article, there was a passage from another commentator's presentation that was made back in 1994, and it says, while case law illustrates that fines continue to be the sentence most frequently imposed in responding to environmental offenses, it is anticipated that as counsel and courts become more familiar with the broad range of available sentence alternatives, other sentencing options will become seen as desirable or even preferable ways to achieve protection of public welfare and environmental quality. Well, that was in 1994, and I think we're at that point now. That's my impression. I don't, in my experience, get the feeling from the judiciary that there's any reluctance at all to imposing these types of sentences in the regulatory context. Just the opposite. However, and this is understandable, the court does want to know that the structured sentence that's being recommended is, practically speaking, going to be enforceable, is going to be effective, is going to be credible, is going to be accountable. So those are the types of things that you would want to address and should be addressed from the counsel's point of view. And I include that responsibility as stretching both to the prosecution and the defense, especially when these things are the product of a joint recommendation to a sentencing court. This opportunity to do more with the sentencing process is reflected in the content, certainly, of virtually all federal regulatory legislation. All of that legislation now has a fairly detailed infrastructure that allows or provides the legislative tools to do this. So the legislation now, generally speaking, at least at the federal level, and I think at the provincial level to a large extent as well, has recognized that the sentencing process in the regulatory sphere is an opportunity to do more than simply impose a monetary penalty and walk away and be done. And as Hughes and Reynolds said in their article, and I mentioned this in my paper, the potential is there to use creative sentencing for larger goals of direct environmental benefit where the polluter pays. And I think that's a very good way of putting it. And I noticed in Peter's paper, he says basically, it's not a matter of whether deterrence is addressed, it's a matter of how you address it. And I think that's a good way of understanding, certainly the way I try and understand the sentence negotiation process in the regulatory context. That, I want to emphasize that from the Crown's point of view, I think the primary sentencing principle, general deterrence, has to be respected and addressed by any sentence, no matter what its form. So that's a fundamental, as far as I'm concerned, from the prosecution perspective. So however you structure it at the bottom level, in order to be something that the Crown would agree to, it does have to address that fundamental principle. And if it doesn't, then it's a non-starter. But assuming that your sentence in terms of its totality satisfies or addresses that fundamental principle properly, then I think the door is open to things that will have more than a simplistic deterrent effect, and will actually make hopefully, some kind of identifiable or tangible contribution, will have some kind of identifiable benefit to societal purposes and values. Now, what I wanted to get at a little bit, I don't think we need to spend a lot of time on it, is, okay, how does this idea play into sentence negotiations, I guess, and maybe more at a theoretical and practical level? How do you go about producing these results and reaching agreements with a defendant? And I really do think that it's effective to frame the issue as an opportunity for the defendant to actually make some kind of tangible, beneficial contribution. It engages, in my experience, it engages the defendant. I find there's a greater willingness to talk in those terms in the sentencing context than there might be in the context of a simple, how much is the fine going to be type of conversation. And I think this, and I find it, especially when obviously the defendant is looking to acknowledge responsibility for the offense and negotiate a sentence. There's a real receptiveness to that type of conversational framework, and I think it probably in the presentation yesterday afternoon on the corporate perspective, I think it's definitely the product of the types of values and considerations from the corporate perspective that were identified. And I see no reason why those types of interests can't be addressed in the context of sentence negotiation and still produce a sentence that the public generally could see as legitimate and effective. So, and just to, as an aside, one of the questions earlier included the suggestion that, you know, these creative sentences oftentimes seem to, at least the ones that get reported, seem to involve these larger corporations with the greater financial and resource wherewithal to address them. And maybe there's an impression that you know, the content of these sentences are actually produced by the defendant themselves, as opposed to suggested by the Crown or other independent sources. And I don't know if that's the impression or not. I can tell you that it's not the reality, at least not in my experience. And I agree with Peter. I think the initiative is generally the Crown in terms of the potential content. It is in all of my cases, I can tell you. That's not to say that I don't listen to a defendant if there's suggestions from the defendant that might work or might address the types of things that I want to address or I think are appropriate to address in terms of an overall sentence. But I think the initiative, generally speaking, is from the Crown. The structure, generally speaking, and the direction of a sentence is the product of the Crown's evaluation of the situation and consideration. In the federal context, I see some of the things that Peter has identified in terms of maybe a bit of a lack of resourcing or background support. But I'm not, on the other hand, I do find that many federal regulatory agencies have the expertise and the willingness to assist and advise when it comes to whether a particular proposal, a particular type of project, for example, is appropriate, is viable, is responsive to whatever the environmental protection issue may be. So I think I can say, generally speaking, I find there is a support mechanism, a resource available at the federal level in many instances because I don't personally have the expertise, I can say, and I don't think most prosecutors do, to address these types of issues without a lot of assistance. And it is there more often than not. And what I'm finding as time goes by is that this is being it's not something that I have to go and find. It's something that's being offered up by the whatever regulatory agency might be involved. So that I think is very helpful. So this idea of deterrence and advancing, issues or values beyond deterrence as being not mutually exclusive, but things that can be addressed effectively together, I think has produced a lot of sentences that do both and address both very effectively. And I've listed a few examples in my paper of that type of sentence in the Atlantic region, and I know that there's been other examples mentioned over the last few days of similar types of sentences in other areas. And in the Atlantic region, yesterday there was some talk of how the split, what the split is in terms of fine versus creative sentencing options in terms of cost. And if you look at, for example, the cases that I mentioned in my paper, that the splits are similar. The fine, what's classified as a fine is taking a reduced chunk of the overall penalty in favor of other expenditures. And again, I think that's just another reflection of this recognition that a fine isn't necessarily the most effective thing, and in fact, you might be missing an opportunity if you don't go consider options beyond that point. So, I guess just to conclude, my simple point is just that the sentence negotiation process should be viewed as an opportunity, that framing the conversation with the defendant in those terms can be a very effective thing. It can address the types of values and concerns that, for example, a corporate defendant might bring into play. But it also allows an opportunity to effectively address the primary purpose of the sentence, which is deterrent, and do more. And so, for example, in the sentences on the cases that I've mentioned, and certainly I think it would apply to some of the other cases that have been mentioned by other speakers, you end up with sentences that address deterrence. They certainly do, but they also address environmental restoration and rehabilitation, future environmental protection, resource and development, education, identifiable, tangible societal benefits beyond a fine that disappears into the public purse, never to be heard from again. And as I say, I think that especially in the regulatory context, is not the best result. I think that's...
Great, thank you very much. I'll come down again and close to the microphone for purpose of questions. Again, happy to take questions from inside, and then we have a few and maybe some more that have come in as well.
So I think the question goes to both speakers, and maybe Michelle, when it comes up later, but I know that some of you are leaving, so I want to ask it now. One of the things that I'm wondering about is, having not been involved in any actual sentencing processes myself, but having done a bit of work on the side, or as assistant, the importance of parity, right? And we know that parity is an important principle in sentencing, like offenders and like circumstances should be dealt with in a similar way. How do you deal with parity in creative sentencing context? And that question is almost sort of like a precursor to a relay question, which one of the concerns I have about negotiated sentencing is that there's no product out there actually at the end, oftentimes, for people to benchmark. There's no sentencing decision. It's not clear on what basis something was arrived at. And for me, and I talked a bit about, this afternoon, but I see that as kind of like a stunting in a sense. And I wonder if there would be any appetite, or if there's any room for instance, having the settlement process, but then having those decisions published, having them included as part of the court order, for instance, so that there is something there that future judges can sort of build, and you would then have that ability to sort of, tying back to my first question, which is to sort of build that parity.
This may be a little difficult to summarize, but I think for the audience at home, the question relates to the problem of ensuring parity in sentencing, that like offenders be treated in like manner, and in particular, and something that came up I think a little bit yesterday as well, the lack of the kind of precedential record that we would expect in normal sentencing principles for things that have been negotiated and constructed, even though they may end up as part of the eventual judgment. The negotiation process and the principles that went into creating a creative sentence may not be as explicitly laid out as they would be in a normal sentencing situation. Does that summarize the question well enough? Okay, and I'll turn it over to
You want to take it?
Well, yeah, it's Peter Craig. I guess I'm getting picked up here.
yeah, you're fine on this mic here.
I made a point mentioning in my paper, and this is maybe just a personal predicament for me. I find, in stark contrast to criminal sentencing, finding guiding precedents is difficult in this context. And I don't want to just regurgitate what's in the paper, but when you look at convictions, prior convictions under a particular section, you could be dealing with completely qualitatively different defendants. You could have one multinational company, very well heeled. You could have a small mom and pop type outfit that's just barely getting by. You could have an individual defendant of at some point on the spectrum of financial means, and then you put on top all of that, and these qualities could apply to each of those three types of defendants, whether they're a recidivist menace, with a brutal enforcement history, or whether they're really, and I don't want to be glib about the use of this term, just somebody was charged because of their technical status, for example, in this context, as the owner of a property for which they don't really have moral culpability for creating a remediation event. That's a wide range of comparators as far as I'm concerned. So parity is a principle. It's a principle in the code that applies to these things, but it's just one of many. And striking the balance is a problem. Now, to the other part of your question, I wish there was a more robust provincial court database tracking these things. That's one of the practical problems I experience doing sentence research. I don't know, Paul, if that's your experience, or the experience of any others, but a lot of these decisions that could assist us all going forward don't get reported. So that's a challenge. Both ends of those things are a challenge.
Yeah, I agree. I mean, very quickly, parity is a tough thing to apply in the context of environmental offenses because they're infinitely variable. Right? Every offense has its own particular factual situation, its own particular type of environmental damage, its own particular context, and what's appropriate in one may not translate at all to another. So, you know, it's not akin to, I mean, I used to prosecute as a provincial crown criminal offenses, for example, a break and enter, where there would be a well-established and published sentencing range from which to work. Because to one extent or another, a break and enter is a break and enter, you know, it might be a smash and grab or it might be a home invasion, but there's a range there that's defined and understood factually, whereas that kind of thing I don't think is the reality in the context of environmental prosecutions. In terms of, though, to the extent that sentences can have precedential value, I agree with you when you say, you know, there's a lack of published reference. There's nowhere to go. That's the result of, I think, to a large extent, the fact that many of these sentences are the product of joint recommendations that don't generate an actual sentencing decision from a court. So they don't get published in the way that decisions often do. There are generally, though, orders that do reflect the content of the sentence that are available to the public upon request. Oftentimes, the sentencing process includes an agreed statement of facts as to the circumstances giving rise to the charge and the offense, and those would also be publicly available. It's just that, that you know, you'd have to go beyond published resources in order to get them. The other thing I should mention is that many federal regulatory agencies actually make this type of information available on their websites. So there will be a section on a particular enforcement agency's website addressing enforcement initiatives and enforcement actions and prosecutions and detailing you know, the background and the results. So those are resources, but you're right, there is a gap there. And it would be better to try and address that in a way that's better done, but we're not there.
Thank you. I would note that we did make some small progress on this yesterday when I think we established the two benchmarks at either end of the spectrum as the Snidely whiplash or the Dudley do-right. So we'll take that as a technical term going forward.
Yes.
Anybody else on the floor? Yes, John.
Yeah, thanks, Phil. I just wanted to agree with the two of you, at least my experience in my former capacity as Crown Counsel. These cases are typically, that is for cases for a creative sentence, are driven by the Crown. It's always, with a couple of exceptions, literally one or two exceptions, it's really come from myself to the other side as to a proposed resolution of the case using the so-called creative sentence provisions. On parity, I've always, when I was with the Crown, I took the view that I always equated parity and proportionality, and I know that the legislative drafters and the legal scholars say you can't mix them together, but I always think they can be mixed together, because I think all you're talking about is fairness. But I would say this as well, that don't be surprised that your colleague on the defense side is going to yard out that one case from Timbuktu and saying, well, look at Your Honor, in the X case, which you probably never heard of because there's no precedence, but in any event, here's an example of parity. So
I think the way you, both of you qualified it is the way you go. I mean, I hope that's helpful to Martin, that yeah, parity here is so limited because there's such the bank of cases just isn't full to make comparison for the reasons that Peter said, the facts of the cases, but you still can't get away from parity and proportionality, or as I call it, fairness.
Just to very quickly summarize that, because I think it'll come back into it's all right. First, that the issue of parity is inextricably, if not widely agreed, to be coupled with proportionality, and that the coupling of those two is essentially a broad concept of fairness. And second, that in assessing particularly proportionality and parity, I guess, we've got to be careful of individuals cherry picking the one case that is brought forward to establish parity, when in fact, as the speakers have said, there's a multiple range of factors involved in establishing that in any given case. Is that a fair, quick summary before I turn it?
Fair enough.
Phil, if I may, I'll just, I don't want to overstate or mislead anybody. I agree with Paul, and I agree with your comments. I think the Crown is usually more philosophically aligned, let's put it that way, with development of a creative sentence regime. But I've gotten some very good input. Paul made the point, and I think he and I are likely on the same page here. I don't purport to be, especially in dealing with corporate defendants, an industry expert. You know, what might be a good form or a good initiative? I've gotten some actual very helpful feedback from defense counsel once the conversation got started. But usually we initiate the conversation, and I'm not saying that to claim ownership over the idea. It's just that, you know, we probably have more collective experience dealing with it, and that's usually how the process begins.
Okay, I have a couple of written ones I'll revert, and we can come back to the floor. This is one, I'm going to combine a couple of questions that come up on one issue and merge it into one long one, largely for Paul on this one initially. We note in your paper the use in the Corner Brook open paper case of an irrevocable letter of guarantee for $500,000 deposited with the court as a security against completion of construction of an effluent plant, which is one of the terms. A few questions. One, has this been done elsewhere? Second, if it were to be forfeit, if the security guarantee were forfeit, does it then become considered part of the fine, or is it some other category of payment into court? And third, in the event of a disagreement over fulfillment of the terms, is that resolved entirely by the presiding judge, or is there any other process involved?
Okay, well, there's a lot of questions there.
Yeah. It's an interesting one. I can see why it's come up.
Yeah. I'll answer yes to the last question. It would be and in this particular case, as was mentioned in terms of the way some other orders are structured, it was expressly addressed in the order that in the event of that type of problem, the sentencing court reserved the jurisdiction to address it and decide it. So there would be a mechanism there. In terms of what how you would categorize the $500,000 deposit, whether it would be a fine or a part of the penalty, I don't know how you would categorize it. It certainly would be. I mean, the idea obviously was one of accountability, one of enforceability, to ensure that the particular project that was ordered to be completed was done, and that significant consequence would be attached to the failure to do so. So in this case, it didn't become an issue. There was compliance with that portion of the order, so that never had to be engaged. But I don't know if there had been a failure to meet that, and the $500,000 deposit was forfeit, then I suppose that would tie a bow on the end of that prosecution, but it would certainly open up the door to another one, wouldn't it?
Yes.
Because presumably the offense would be continuing after that, which I think might have been a significant motivation for the people involved to actually comply with the order.
If I can just add, the Provincial Act also provides for a similar mechanism. And a judge can order the posting of a bond. That's the language in the provincial statute. Now, I've looked at that section on more than one occasion, considering whether I would seek it. And I'll tell you the context just very quickly. We'll deal with a prosecution breach of an administrative order to have some form of remediation work done, for example, or even the breach of a ministerial order, which in this province is sort of one level above in terms of an administrative order. And you're dealing, generally speaking, with somebody in this category that has a recidivist problem. And for breach, if we were to prove the breach of one of these orders, we would look for the judge to impose a sentence order, effectively capturing the same amount of work, and against which we could seek the posting of a bond. Now, I'll candidly state to everybody here, we've never had to look for execution, or I'm not sure what the right civil language is, of a bond in those circumstances. I don't know if that's ever happened, and I don't know how it would happen in provincial court, quite frankly, because these are things that would typically happen in any other setting in Supreme Court in this province, I think. I can tell you our prosecution service wouldn't have any experience trying to draw down on a bond that was posted into provincial court, if I can frame it that way. The statute appears to provide for it. The mechanics of how it would be done admittedly escape me. Maybe others here might have an idea. I certainly don't.
Image of the court administrator going down to the local bank to cash the $500,000. I think we're almost at an end. There's a couple of questions left. One related again to the question of the very significant judgments, and not just the large corporate offender question, but the fact that many of the examples of creative sentencing, for example, in Paul's paper, have referred to very significant judgments in general in terms of the size and scope. Theme that emerged yesterday as well in Professor Ingelson's review. Do you find as much room for this creative thinking in sentencing for the somewhat more minor offenses or in cases involving defendants without deep pockets, if you want to look at it that way? So not a question of who initiates it, but are they appropriate to those cases?
I'll jump in quickly. I think very much so. We've leaned very heavily on creative sentence options in environmental cases and occupational health and safety cases where a defendant, be it an individual person or a very small, closely held company, just didn't have the financial means to pay a fine in the usual range. And look, I fully get the objectives of the sentence, but you know, in my experience, we're dealing with a corporate defendant or an impecunious individual person. Courts are loath to bankrupt individuals or put small companies out of business by way of sentence. And in fact, some judges say you're essentially setting up a defendant for a breach. That's the language we hear in court, notwithstanding what a fine range may otherwise dictate. So in those instances, what are the options? Well, maybe having somebody do a significant amount of community services work, for example, is the way to go. And we've done that, and I've seen those types of sentences to be responsive.
Yeah, I agree completely with that. I think there's value to this in the smaller, less spectacular set of circumstances, one that might not include as many zeros as some of the sentences imposed here. In fact, in those situations, there might be even more room for what you might call creativity in terms of dealing with these situations. You know, I can think of one quick example where we had a small logging company that did an awful job on a viable trout brook. And as part of the penalty, because this company actually had the equipment to do it, they were ordered to take some remedial and environmental enhancement action at another location that needed it. So to me, that's an example of how it can have value even at a lower scale. I don't know it would certainly have been a cost in terms of time and equipment to this person. You know, might be hard to quantify it financially, but I think it did have a deterrent effect, and it did have an identifiable benefit.
Thank you. One last question, which I think is appropriate place perhaps to end the time, because it, I think, reflects a certain recognition and sympathy for the role of prosecutors, put it that way. The kinds of sentencing arrangements discussed in the examples in both papers would presumably be more time-consuming for the prosecutor to develop and implement. To what extent is this acknowledged in assessing the workload of a prosecutor? That is, can a caseload-driven performance standard for prosecutors act as a disincentive for getting involved in such arrangements?
You're going to have to take that one, Paul.
Here's a softball.
You're going to have to take that
I
one.
don't get the impression that anyone really cares about my workload.
Presumably management is not logged in at the moment.
Yeah, sorry. Yeah, maybe I'm looking for a job at Walmart after this, I don't know.
You're on the web, Paul.
Yes.
Okay, anything to add to that, Peter?
No, not really. Not really.
Thank you both for really an excellent interaction this last one, and thanks for